The Wage and Hour Division, or WHD, of the U.S. Department of Labor, or DOL, is responsible for enforcing federal wage and hour laws. These laws include the Fair Labor Standards Act, or FLSA, the Family and Medical Leave Act, or FMLA, and the Equal Pay Act, or EPA. The WHD enforces wage and hour laws through a variety of actions. Firstly, investigations. WHD investigators can conduct investigations in response to complaints or as part of scheduled compliance reviews. They may interview employees, review payroll records, and examine other documents to determine compliance with labor laws. Secondly, conciliation. WHD attempts to resolve violations through conciliation, which involves negotiating a settlement between the employer and the affected employees. Thirdly, enforcement litigation. If conciliation fails, WHD may initiate legal action against employers who violate wage and hour laws. This can result in penalties, fines, and back wages for affected employees. Fourthly, administrative penalties. WHD can also assess administrative penalties for certain violations, such as failure to maintain accurate time and payroll records. Employees who believe they have been denied wages or benefits under federal wage and hour laws can file a complaint with the WHD. Complaints can be filed online or by mail. While WHD has broad authority to enforce wage and hour laws, it does not have the same level of inspection authority as OSHA. OSHA can conduct unannounced inspections of workplaces to ensure compliance with health and safety regulations. WHD, on the other hand, typically conducts investigations based on complaints or as part of scheduled compliance reviews. However, WHD still has the power to investigate violations, issue citations, and impose penalties on employers who fail to comply with wage and hour laws. Employees who suspect violations are encouraged to file a complaint with the WHD. The Fair Labor Standards Act, or FLSA, establishes minimum wage, overtime pay, record-keeping, and child labor standards affecting full-time and part-time workers in the private sector and in federal, state, and local governments. The FLSA is enforced by the Wage and Hour Division of the Department of Labor. The FLSA requires employers to pay covered employees who are not otherwise exempt at least the federal minimum wage of $7.25 per hour. Overtime pay at a rate of not less than 1.5 times the regular rate of pay is required after 40 hours of work in a work week. The FLSA includes provisions for youth employment. It sets restrictions on the types of jobs young workers can perform and the hours they may work. The FLSA requires employers to keep records on wages, hours, and other items. These records do not have to be kept in any particular form and are available for inspection by the Wage and Hour Division. The Family and Medical Leave Act, or FMLA, entitles eligible employees of covered employers to take unpaid, job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. The FMLA is administered by the Wage and Hour Division of the Department of Labor. Eligible employees are entitled to 12 work weeks of leave in a 12-month period for the birth of a child and to care for the newborn child within 1 year of birth, for placement with the employee of a child for adoption or foster care, and to care for the newly placed child within 1 year of placement, to care for the employee's spouse, child, or parent who has a serious health condition, for a serious health condition that makes the employee unable to perform the essential functions of his or her job, any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on active duty or called to active duty status. Eligible employees are entitled to 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the employee is the service member's spouse, son, daughter, parent, or next of kin. The Equal Pay Act, or EPA, protects men and women who perform substantially equal work in the same establishment from sex-based wage discrimination. The EPA is enforced by the Equal Employment Opportunity Commission, or EOC, but the Wage and Hour Division of the Department of Labor provides technical assistance to the EOC and to employers and employees regarding the EPA. The EPA prohibits wage discrimination between men and women in the same establishment who perform jobs that require substantially equal skill, effort, and responsibility under similar working conditions. The EPA covers all forms of compensation, including salary, overtime pay, bonuses, stock options, profit sharing, and benefits. The EPA provides exceptions for wage differentials based on seniority, merit, quantity, or quality of production, or any other factor other than sex. If an employer violates the EPA, it may be required to pay back wages, liquidated damages, and attorney's fees. The Wage and Hour Division of the Department of Labor has the authority to investigate possible violations of the FLSA, FMLA, and NEPA. The WHD can conduct investigations in response to complaints or as part of scheduled compliance reviews. As part of an investigation, WHD investigators may interview employees, review payroll records, and examine other documents to determine compliance with labor laws. If the WHD finds that an employer has violated the FLSA, FMLA, or EPA, it can take a number of enforcement actions, including conciliation, enforcement litigation, and administrative penalties. Conciliation involves negotiating a settlement between the employer and the affected employees. If conciliation fails, the WHD may initiate legal action against employers who violate wage and hour laws. This can result in penalties, fines, and back wages for affected employees. The WHD can also assess administrative penalties for certain violations, such as failure to maintain accurate time and payroll records. Employees who believe they have been denied wages or benefits under federal wage and hour laws can file a complaint with the WHD. Complaints can be filed online or by mail. The WHD provides a variety of resources to help employers comply with the FLSA, FMLA, and NEPA. These resources include publications, training programs, and online tools. The WHD also has a toll-free helpline that employers and employees can call to ask questions about wage and hour laws. The FLSA, FMLA, and EPA are important laws that protect workers' rights. The Wage and Hour Division of the Department of Labor is committed to enforcing these laws and ensuring that workers receive the wages and benefits they are entitled to. Here's a more detailed breakdown of the enforcement actions that the Wage and Hour Division, or WHD, can take. Regarding investigations, the WHD can conduct investigations in various ways. These include complaint-initiated investigations, where investigations are triggered by complaints filed by employees alleging violations of wage and hour laws. The WHD also conducts strategic enforcement, which involves targeting industries or geographic areas with a history of violations or high risk of non-compliance. As part of the investigation, the WHD has brought authority to gather information and evidence. This includes interviewing employees, both current and former, to gather information about their work conditions, pay rates, and hours worked. The WHD can also review payroll records, timesheets, and other documents to verify compliance with wage and hour laws. They can also enter and inspect workplaces to observe working conditions and gather additional information. If the WHD finds violations during an investigation, they will attempt to resolve the issues through conciliation. This involves working with the employer to reach a settlement that includes back wages for affected employees and a commitment to future compliance. Conciliation is often the preferred method of resolution, as it can be faster and less costly than litigation. However, if conciliation fails, the WHD may pursue litigation to enforce wage and hour laws. This can involve filing a lawsuit in federal court against the employer. If the WHD prevails in court, the employer may be required to pay back wages, liquidated damages, civil penalties, and attorney's fees. Liquidated damages are typically equal to the amount of back wages owed, effectively doubling the amount the employer must pay. In some cases, the WHD may also assess administrative penalties for violations of wage and hour laws. These penalties can be substantial and are in addition to any back wages or damages owed. For example, penalties may be assessed for willful violations of the minimum wage or overtime provisions of the FLSA. The WHD also has the authority to seek injunctions to prevent employers from continuing to violate wage and hour laws. An injunction is a court order that requires the employer to take specific actions to comply with the law. Failing to comply with an injunction can result in further penalties, including contempt of court charges. In addition to its enforcement activities, the WHD also provides education and outreach to employers and employees. This includes providing information on wage and hour laws, conducting training sessions, and participating in outreach events. The goal of these efforts is to promote compliance with wage and hour laws and prevent violations from occurring in the first place. The WHD also works with other government agencies to coordinate enforcement efforts and share information. This includes working with the Department of Justice to prosecute criminal violations of wage and hour laws. The WHD also works with state and local labor agencies to address wage and hour issues at the state and local level. Employers should be aware of the various enforcement actions that the WHD can take and take steps to ensure compliance with wage and hour laws. This includes maintaining accurate records, paying employees properly, and providing required benefits. Employees who believe their rights have been violated should file a complaint with the WHD. The Wage and Hour Division is committed to protecting the rights of workers and ensuring that employers comply with wage and hour laws. Remember that while the WHD doesn't have the same level of unannounced inspection authority as OSHA, they do have significant power to investigate, issue citations, and impose penalties on employers who fail to comply with wage and hour laws. Filing a complaint with the WHD can be a crucial step in protecting your rights as an employee. The process generally involves these steps. Firstly, gathering information. Before filing a complaint, gather all relevant information related to your claim. This may include pay stubs, timesheets, employment contracts, and any other documents that support your case. Secondly, completing the complaint form. You can file a complaint online or by mail using the WHD complaint form. The form will ask for information about you, your employer, and the specific violations you are alleging. Thirdly, submitting the complaint. Once you have completed the complaint form, you can submit it to the WHD online or by mail. The WHD will review your complaint and determine whether to initiate an investigation. Fourthly, the investigation process. If the WHD decides to investigate your complaint, they may contact you and your employer for additional information. The investigation may involve interviews with employees, a review of payroll records, and an inspection of the workplace. Fifthly, resolution. If the WHD finds that your employer has violated wage and hour laws, they will attempt to resolve the issue through conciliation or litigation. This may result in you receiving back wages, damages, and other remedies. It's important to note that there are time limits for filing complaints with the WHD. These time limits vary depending on the specific law that has been violated. It's advisable to file your complaint as soon as possible after the violation occurs to ensure that your claim is not time-barred. Remember that the WHD takes all complaints seriously and will investigate them thoroughly. Filing a complaint is a protected activity, and your employer cannot retaliate against you for doing so. If you experience retaliation, you should report it to the WHD immediately.